Further hearing the appeal of emotional perception AI Limited against Comptroller General Patterns Design and Trademark.
Yes.
My Lords. May I please report. Yesterday we were discussing the judge's summary of the technology, and we had that in the judgment, page 147 of the bundle. And as your Lordships can see on page 148, the judge helpfully cross-refers in his discussion to figure 6 from the patent application. And we have that in a legible version on page 222 of the bundle.
It may be legible to you. I'm not sure legibility will much assist, but...
Sorry, you have it as well on 222. You should have a large version of it.
Yes. It may be large. I'm not sure it makes it all too much harder.
Let me assist with that further, my Lord. Depicted on the left-hand expanded box is a single artificial neuron, as explained by the judge in paragraph 8 of the judgment.
Yes.
This is capable of processing inputs and producing an output which is passed on to neurons in other layers. Just picking up in the figure, on the left-hand side we have inputs x1, x2, x3, all the way through to x sub r in this example. These feed through to the summing junction marked 730, depicted by a summation sign, which is the Greek capital sigma. And the connecting lines between the inputs x1 to xr include so-called weights for each corresponding input, denoted w sub I, 1, all the way through to w sub I, r. And the summation block adds up the weighted inputs such that the output of the summation block, helpfully called a sub I, is the sum of the weighted inputs. So here, the output from the summing function for the ith neuron is x1 times wi1 plus x2 times wi2, and so on. Also added into the summing function is something called the bias, which is a constant signal calculated by multiplying 1 by the special weight bi, which we see coming into the bottom of the summing block. Now, the sum of the weighted inputs and the bias for the ith neuron, called confusingly AI, is fed into the nonlinear activation function f. Now, there are different types of known activation functions, but typically they're nonlinear functions, such as a continuous sigmoid function. And the output of the ith neuron, here depicted yi, is calculated by applying the nonlinear function to the summation ai. And as Lord Justice Burse explains at the end of paragraph 8, such activation functions act substantially like a switch. If the signal of all the weighted inputs is greater than a fixed threshold, then the neuron activates or fires, and its output goes to 1. For values of the summed weighted inputs less than a threshold, the neuron doesn't activate, and its output yi is 0. Now, there's a slight wrinkle in that, as Lord Justice also mentioned, depending on the precise type of activation function, there is usually a linear or proportionate section in the middle, where yi is scaled by a value of ai. And this is generally necessary for certain mathematical reasons associated with training. But conceptually, we can think of it with that switching function during normal operation. Now, as we can see in figure 6, this is just one neuron in the entire neural network. The network as a whole is arranged into layers, starting at the input layer on the left-hand side, where we have a number of inputs, I1 through to I sub n. On the right-hand side, each of the outputs depicted from output neurons each of the outputs from the 3 depicted input neurons in the first layer form the inputs to the neurons on the second layer, and so on until we reach the output layer where we have outputs O1 through to OM.
What is the neuron 704 in the first layer? I think you said there were 3 neurons in the first layer.
So the first layer is the input layer where I1 goes into the first round circle, I2 goes into a circle, and IN goes into a circle. So that's the first layer, the input layer.
Okay.
Then we have the first hidden layer through to the kth hidden layer, and then we have the output layer, which is shown. Now, although we can depict the essential features of a neural network using the small example in this figure, practical neural networks typically involve a lot more neurons and potentially a lot more layers. The example given in the patent application, for your Lordship's reference, it's on page 268, line 25, is at least 2 hidden layers, so 4 layers in total, plus the input layer, the output layer, and the 2 hidden layers. And we're actually told there are 512 neurons in the first hidden layer and 1,024 neurons in the second hidden layer. So just standing back, a neural network consists typically of hundreds or thousands of generic artificial neurons, arranged generically into cross-coupled multiple layers, forming a generic structure from the input to the outputs. And what we have thus far is just a generic neural network.
And that, for this application, is something pre-existing, that they adopt a particular neural network that somebody has designed in the past?
Exactly, my lord. One can choose how many layers one has.
Right.
And one can choose how many neurons one puts in a layer.
Right.
But the structural design is standard form. That's what Lord Justice Burse calls the naive neural network. And Lord Justice Burse gives a very simple example of a task which a neural network might be used for in paragraph 10 of the judgment. It is the simple task of recognizing if an image presented to the input is of a dog or of a flower. What we want is that if the image presented to the inputs is a picture of a flower, we get a signal, a 1, from output 1, but a 0 from all other outputs. And if we input into the same neural network an image of a dog, we get a positive signal on output 2, but no other output. Now, the type of problem which neural networks are good at assisting with are what we call pattern matching or classification. Problems such as classifying whether an image is of a dog or of a flower. And such neural networks can be trained to take new, previously unseen input data and classify it according to their training. I've never seen this image before, but it seems to have the properties which are much more like a flower than a dog, so I will classify it as a flower.
What it basically, it gets presented with a whole lot of different pictures of dogs, so of different kinds of dog, and through its training process it learns to identify the features which typify a dog, so, through the distribution of weights and so on throughout the network. And the idea is that then when you present it with a new image of a dog, not in its training database, it'll run through and it'll produce dog as the output. Is that the basic...
That's basically it. Your Lordship has it. That what's explained by Lord Justice Burse is the training process as the training data set, which, as my Lord Legate refers, has lots of different pictures of dogs, lots of different pictures of flowers. But the important thing about the training set is we know which are dogs and which are flowers. So when we present them to the network, the first outputs we get from the untrained neural network aren't going to be right. But by using an error function, sometimes called a cost function or a loss function, we find the difference between the output we wanted and the output we got. And then we use a training algorithm, such as backpropagation, to go back through the network, subtly adjusting each of the weights and biases to reduce the error. And the idea is, as we keep presenting more and more images, and over time making incremental changes to the weights and the biases, we will approach the point where, as my Lord Legate says, the algorithm or the network has learned sufficient characteristics of the input data that it's being shown to be able to correctly classify between what we've been asking it to classify. And Lord Justice Burst carries on with the validation set. Now, the validation set is another set of data that we also know the outputs to. But we can test how well our algorithm or our neural network is working by presenting now the validation set and running through it and seeing how many dogs it gets right and how many flowers it gets right. But the important thing with the validation set is we don't use it to make any changes to the network weights and biases, because if we do, we're suddenly teaching the neural network to learn the validation set as well as the training set. And that's important when we're considering matters such as, I think Lord Legate mentioned yesterday, we want to be careful not to overtrain the network so that it remains having the capability to generalize. So when we've presented the training set time and time again, making the increments, and then we've tested it with the validation set, if the validation isn't good enough, the network goes back for more training. If we are satisfied with the training, we then can freeze the network. At that point, the network is frozen and capable of being put into use. Now, my Lord Briggs asked yesterday whether weights that have been frozen can be unfrozen. And the answer is they can, provided one is still in the training environment where there remains a mechanism to change them. So, for example...
But I thought you just said that if it passes validation, then it doesn't go back to training and it's frozen. So how can it still be in the training environment in that sense?
So at that stage, you do freeze and stop, and you don't go back and change the weights and biases ever again. The point that I was about to make was that during validation, for example, we temporarily freeze the weights and biases, run the set. But once we finish training and we are satisfied the job is complete, they're frozen and they remain frozen, unless we decide to go back and do some more training because we discover some problems when we put it into use in the real world. And at this point, we move to what we call the inference stage. And the concept at this point is that we should be able to take a brand new image of a dog or a flower, one which the neural network has never been shown before, present it to the inputs and get the right answer. And to be clear, there's no actual intelligence as such in a neural network. Rather, what training creates is a complex mathematical function between the inputs and the outputs, which is entirely deterministic. A network will always do the same thing, but it's capable of generalizing from the data it has been shown during training to infer the right answer for new data which has never been seen before.
And why is that not an intelligent function?
That becomes a philosophical
Yes.
debate.
But if it matters to your submission, it might help to know why not.
The point that I'm making, my Lord...
The point that it's deterministic.
It's entirely deterministic,
okay.
Yes. Now, an example from this arises which may help. Assume, hypothetically, that all of the images of dogs used for training display what I would describe as typical dog colours. Browns, blacks, maybe whites, but overall muted animal colours. And assume, hypothetically, that all of the images of flowers used for training display what I would describe as bright spring and summer colours, vibrant yellows, reds, purples, and so on. Everything is working fine in my trained neural network. The validation set has similar properties and is giving me really good validation results. So I stop training, freeze the weights and biases, and move on to the inference stage. Again, everything works fine until I present an image of a poodle which has been dyed bright pink. The neural network has never been trained on a pink dog. There are lots of things in the image which suggest the characteristics of a dog rather than a flower. but pink screams flower. If the neural network has used colour as an important differentiator in the training process, it may well be the case that faced with the pink poodle, colour wins out and we get a classification that the pink poodle is a flower rather than a dog. Now, of course, when we see these types of error, the data scientists responsible for training the neural network will want to determine why the error occurred. In this case, because we never thought to train the neural network with images of unnaturally coloured dogs. And if being able to handle the pink poodle case is important to those training the neural network, then it's a failure, a bug, if you like.
Do you do that sort of test at the validation stage?
Not in conventional validation. As Lord Justice Burst describes validation, it's the routine process of taking the data and pushing it through. And one of the issues that one might see is whatever the data scientist thinks is an appropriate selection of, in this case, images for the training set, very often the same errors can be made in the validation set. So, depending on what happens in practice, you may, for example, have a separate team put together the validation test so they don't know the assumptions that have been put together by whoever was putting the training set together, so as to try and catch these cases that are issues of perception by the data scientist. Other times, you may end up with the network going out into the real world, being used, and then coming across these cases that were not expected in practice. And that comes back to my Lord Briggs's point about the freezing and unfreezing. If you are dissatisfied with your product once it gets into the marketplace, a bit like a beta release of any software package, bugs turn up when it hits the real world, then it may be that the data scientist wants to go back and revise the training that they did previously, much like we would say a programmer discovering an unexpected case with a normal program, goes back to the program, revises it, and tries to remove the bug. So what then is the difference between the generic untrained neural network and the one trained to perform a particular task? Quite clearly, it is the set of all the weights and biases which have been determined by the training process, and they can be used in a fixed or a frozen state to address a particular task. It is that set of weights and biases which instruct the generic neural network to process the input data in such a way as to give the desired outputs.
Well, that's where the issue comes, isn't it, when you say instructs? Because as I understand it, the weights and biases are just numbers, they're values. And a number doesn't instruct you to do anything. It's just part of the information that the system uses to generate the output.
They are, my Lord, and I can deal with that straight away while we've got figure 6 in front of us. Input data appears on input x1, and the generic neural network needs to know what to do with it. There's a certain amount which is predetermined, which is going to multiply it by a weight. But what weight does it use? What number it uses to process that to sum into the summation block, and whether it uses x2 at all, whether the weight for x2 is 0 or whether it's some other number, is defined entirely by the weights. The only thing in the system that tells the generic neural network how to process the input data is these are the sets of numbers you need to operate with. Just in many ways, in a computer, the program, which is in memory, stored often in binary, is just a set of numbers. But those numbers are stored in such a way that they have a meaning to the computer architecture to tell it what to do.
In the context of would your submission be that in the context of one of these systems, these are the equivalent of the programming instructions in a more conventional computer?
Well, quite, my lord.
Is that, I'm asking if that's your submission.
That is my submission, because what we're looking at is the set of numbers, because ultimately computer programs are just sets of numbers.
Well, they are ultimately, but what characterises them as programs is that they are a set of commands, or they're a set of rules, instructions, which you can write at one level in a code, and then maybe machines translate it into more detailed code, and then maybe ultimately into sets of numbers. But you can't. Weights and biases are never a set. At no level are they a set of instructions or commands.
My lord, in many ways they are. My submissions are that they are, because they're not just numbers. It's not just 5 and 3 and 2 and 1, in the same way that a computer program ultimately is just a set of numbers. But the way that they're stored in a computer program, the numbers mean things. They tell the computer what to do with the input data. And in precisely the same way here, the set has a meaning. You can't just put the number 5 in weight 1 or the number 5 in weight 2. As a set of weights and biases, it is use 5 as weight 1, use 4 as weight 2, use 3 as weight 5, for example, and use this number as the bias. It is a structured set of instructions that tell the network to do a particular input data processing exercise.
An example of that would be if you presented the same song 100 times to a trained ANN, the aim is to produce the same result on every single occasion.
Absolutely.
Repeated 1,000 times.
Just like a computer, it is entirely deterministic, dictated by what those values of weights and biases are.
Yeah.
Does it matter who or what decides on the weights and biases? I mean, in a computer program, as I think I understand it, the programmer, who's generally speaking a human being, decides what commands it's going to specify in the program that the computer then has to follow. As I understand it, the critical difference with an ANN is that when it's being trained, it decides what the weights and biases are to be as a way of getting to pass validation in due course, i.e. as a response to its being trained. And what the programmer does, if that's the right way to describe the person, is actually simply to specify the training program and then specify the level of sophistication of the validation program.
I understand the point that your lordships make. I mean,
You may say it doesn't matter, but that's my question.
My learned friend says in relation to a conventional computer program that the program is able to solve some problem only because they can conceive of the logical set of methodical steps required to solve that problem, and then can code those steps in what my learned friends call the if-then-else statements. Now, in contrast, and picking up my lord's point, my learned friend says that the sort of problems to which ANNs are deployed are that they can, what my learned friends called intractable problems for computer program, by which he means it's difficult to conceive of if-then-else statements. Now, whilst we agree that neural networks are especially suitable for solving intractable problems, such as classification problems, they're not limited to solving such problems. They can be trained for classical tasks, say, adding 2 numbers. And of course, one can also write conventional programs that analyse images and categorise, for example, dogs and flowers. There are different computational tools that are more or less suited to solving different problems. But it's not right to be left with the impression that no one has to think to train neural networks. They do not teach themselves. Simply put, an unskilled member of the public can't generally pick up a neural network, throw a problem at it, and expect it to be able to do a useful specific task. Training a neural network requires a specialist who understands how they work, understands the training and validation data sets needed, understands how to select the appropriate numbers of neurons and layers, understands how to select an appropriate type of activation function for the task at hand, and understands how to condition the input and output data structures to make the problem amenable to successful training and inferencing.
May I just ask one question about your response to my Lord Briggs? Are there occasions when computer programs are in fact generated by a computer?
Yes. As was actually picked up by Lord Justice Burse in the judgment, with conventional computer programs, these days it is very rarely the case that the computer programmer sits down and hand codes the machine instructions which are going to execute on the computer. Even at the most basic level, the computer programmer writes in, for example, a high-level language where they're writing text, but they're writing language through, and they run then software called a compiler to generate the machine output. You can take it to a far greater extreme, and we touched upon this yesterday, of programming languages that make computer programs available to normal people, perhaps, where you can drag boxes around the screen to show the process that you want to do, to define the inputs, define the outputs, and the processes in between. Again, you push a button, and the computer program generates, another computer program, the compiler, generates the output that's run on the computer. And we respectfully say that whether one's looking at the setting up of a neural network, or whether one's talking about programming using a modern high-level programming language, it's all programming activity. It's that which has to be done to set up the relevant conditions for a computer program to take over and generate the machine code which is ultimately run on the computing platform.
On this submission, would I be right in thinking then that the answer to the question may be whether or not the AN is itself a computer? Because if it isn't... the ANN certainly needs to be a computer in order to have a computer program. And I'll come on to that in a moment. But we'd certainly say that the key distinction is between a generic hardware and the ability to program it with a set of weights and biases to do a specific task. Just thinking back to our example, if instead of dogs and flowers, we'd chosen cats and dogs or cats and vegetables, the set of weights and biases we would have got would have been entirely different.
But they are a product of the programming process as you're describing it.
Absolutely.
They're not a program themselves, it seems to me. They're not a set of instructions. They're the product of the training, which, it's, as I would readily accept, is something which the machine is given instructions to do.
But the product of the training is what you can then pick up and reuse. So let's take an example of self-driving cars. In the laboratory, we have an extensive training activity where we work out how to configure a neural network in terms of weights and biases to do the driving exercise. What then happens is the cars come off the production line, and we don't suddenly send them off to driving school to learn for themselves how to operate. We take the file, which has got the weights and biases in from the laboratory, and we put it into the neural network architecture, which potentially has no training function at all. So the last thing we want is cars out in the field to be self-training or altering themselves. We've decided how it should work in the laboratory in a training environment. We then take the frozen weights and biases, and they tell each computer or each ANN structure coming off of the production line how to drive in exactly the same way as the ANN in the lab. And the only time that's going to change
is if I take my car in for a service and further work has been done by the manufacturer, perhaps to fix a problem of cars driving over pink poodles or whatever the issue might be. And they've produced a new set of weights and biases which can be upgraded just like any other computer software in the modern world. And now my car, with no changes to its hardware, will continue to operate in accordance with the new set of instructions which tells that car how to go about driving. We've also, in this context, it perhaps is worth looking at, we've pointed out in our written case from the JA bundle on 1453, we've pointed out from the Copyright Designs and Patents Act 1988. Section 9.3 deals with computer-generated works. And it provides that works which are computer-generated, the author should be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. And we're saying computer programs, which are always, as many of your lordships will know, treated as literary works, come out of computer-generated works. And whether we're talking about a conventional computer program or the weights and biases of a neural network, there is absolutely no doubt it would be treated as a literary work under the Copyright Act, and the author of that work would be the person by whom the arrangements necessary for the creation of the work are undertaken. We say the activity is different to a normal programming language, but it's not the same even for conventional programming languages. What I have to do in BASIC isn't the same as what I do in C, isn't what I do in Pascal. They're different languages, they require different arrangements to be made, and so we say in the same way with a neural network. Now, unless your lordships have any questions on the technical background, I was going to move on to issue 2 itself, which is the construction of a computer program as such. We say this is a pure question of statutory construction. What do the words "a program for a computer" mean in section 1(2) sub C of the Patents Act? Or programs for computers, the plural form, as appears in Article 52, 2C of the EPC. And I'll start with 3 observations. First, when applying the exclusions, much of the debate ends up centering on how we deal with the as such limitation or rider. However, for the statutory construction question, we don't need to get embroiled in the complications of the as such rider. We simply have to consider what programs for computers mean. And my Lord Briggs is looking quizzical.
Well, I am, yes. I'm sorry. but what we have to construe is the composite, isn't it? Program for a computer as such.
Your Lordship's absolutely right that when it comes to applying the Act to any given pattern or something of that nature, of course the as such rider comes in, which means we need to work out how we get to the program for the computer when it's in a system with other components and doing other things. But as a matter of statutory construction, the point that I'm making is that the as such doesn't help us or hinder us when we look to define what the legislature means by program for a computer.
Well, surely you've got to consider the whole of that which you're trying to construe, and bits at one end of the composite phrase may influence one's perception as to what bits at the other end mean.
So your Lordship is absolutely right that in principle we of course need to keep an eye to make sure that the as such doesn't result in a change. But my submissions are there is actually no interaction when we're
well, that's a different point.
Your Lordship has my point now.
I mean, to treat that as an a priori assumption is, to my mind, goes much too far, but you may say that's your conclusion you get to.
That is my conclusion.
In which case you're going to have to justify it.
I'm grateful, my Lord. So the second observation, and quite importantly, the provision doesn't bite on computers Rather, the exclusion is solely about programs for computers. Now, of course, construing programs for computers naturally, if not necessarily, leads one to start musing about exactly what we mean by computer. But it is only programs for computers which the exclusion is concerned with. And given the way matters are argued by my learned friends, and to some extent what has been said by the interveners, we do say this second point is quite important, because a substantial part of my learned friends' concerns are about what a computer is and whether the Court of Appeal's definition of computer is overly broad, so as to cover an electronic filter circuit, a basic smoke detector, an electromechanical toaster, or an old electromechanical jukebox. And the whole point of my learned friends' examples is that the hardware, the machine in these examples, is not programmable, and there can be nothing akin to a program. Now, in that, my learned friend is absolutely right. As he rightly asserts, the statutory expression program for a computer necessarily limits whatever meaning we give to computer to computers which have a programmable architecture. And we agree, as we have said in our written case, in paragraphs 39A, and then discussing further at 40 sub A. And the only caveat we make in our written case is that care has to be taken not to mischaracterize dedicated purpose computers, such as those one might find controlling a household item, such as a washing machine or a dishwasher. These typically contain a computer which is permanently programmed for a specific task. It is still, however, a programmable computer architecture and has a distinct program, even if it is rarely or if ever upgraded or changed. Now, that computer in a dishwasher is architecturally very different to any circuitry or mechanics in my learned friend's electromechanical toaster example. The control computer in a dishwasher could be taken out and reprogrammed, and with suitable interfaces, it could control a toaster or an oven or many other things. It is a programmable computer with a programmable architecture whose specific operation, task, or purpose is dictated by the program which is loaded into it. And in contradistinction, there is no general purpose architecture in my learned friend's electromechanical toaster, which could be programmed to control a dishwasher or an oven or anything else. In essence, the electromechanical toaster, or the bit my learned friend's focusing on it, is an electromechanical timing switch, and it will always be an electromechanical timing switch, whatever product we might choose to put it in. And provided we keep in mind that the Act and the EPC only apply to computer programs, much of my learned friend's concerns, and for that matter, those of the interveners, as to the meaning of computer, we say fall away.
Don't they fall away as well on the basis that they are technical? So a washing machine, if the washing machine contains a computer, then that's a technical application of the computer.
My Lord is absolutely right. And I think this is the distinction my learned friend is trying to say. Well, hang on a minute, these are mechanical devices. They surely can't be excluded, but they would be if they suddenly become computer programs. Well, we're not saying they become computer programs. We accept that they are technical, physical things that don't involve computer programs at all, and therefore they are not caught by the exception.
Just talk me through one of those examples then.
So, for example, one takes the electromechanical toaster.
Yeah, well, that's a timing device, you say.
It's a hardware timing device.
Okay.
Doesn't involve a computer at all. Doesn't involve a computer program. Doesn't have a programmable architecture where it can be made to fulfill a different function. Same with the electromechanical jukebox. It is a machine set up to do one thing, where the hardware is set up and isn't programmable.
It's the fact the architecture is programmable. Is that right?
Exactly.
Is the heart of your submission. Even if even if the program is then fixed
built into the product.
for practical purposes in commercial use, it nevertheless has a programmable architecture.
Exactly, my lord. And the courts have had to deal with this going back at least to Gale in this jurisdiction, where Mr. Gale sought to get around exemptions by saying, well, my program is hard programmed into what's called a read-only memory. And it was argued that in the read-only memory, what happens is that you have fusible links or a mask so that you effectively build the program hard-coded into the hardware. And the Court of Appeal said, that isn't right. This program is driving a programmable architecture. It doesn't matter that you have fixed it. What matters is that the exception applies to programs for a programmable architecture. And that has been followed here without demur. It's been followed the same in the EPO. Because otherwise, the moment one says, well, a computer program on a fixed medium, you escape the exception and you take it away. And my learned friend's example of it's just resistors in a box comes to the same effect. Nobody in reality is going to have a neural network consisting of thousands of neurons and say, now that I've got the training right and I know what the values of the resistors are, I'm going to hand build it out of all of these individual resistors in an attempt to make it a hardware unit. And it's notable that the claims of the applications that one sees for these types of neural networks, nobody ever puts a neural network hand built out of fixed individual resistors. The claim is always directed to, as my learned friends is, to a neural network, be it software implemented, be it programmable hardware implemented, or be it hard-coded. And the courts have long looked at this hard coding and said that doesn't take you out of the programmable architecture point.
And may I ask, are there any authorities which include one or two paragraphs just
Gale, which was cited by Lord Justice Burse in the judgment, is the go-to authority on this.
And can you just please give us the relevant...
Yes, your lordships have got it in the bundle, actually. It's in JA...
I wasn't necessarily asking you to go to it, just give us the references so that we've got it for our notes.
Yeah, it's actually cross-referenced in the judgment at paragraph 62.
Thank you.
And that goes to pages 321 of the judgment, and Lord Justice Burse cites lines 13 to 19.
Thank you very much.
And then the third observation I wanted to make is about conventional computer. My learned friends were yesterday somewhat misstating the Comptroller's position on conventional computers. Now, we've adopted my learned friend's terminology of conventional computers as a convenient way to refer to those computers with a CPU and if-then-else instructions and the like. Now, we also accept that the largest number of computers in the world, as at 2025, are conventional computers. And that was probably true in 1977. We further accept that it is beyond argument that programs for such computers fall within the statutory definition. There's absolutely no basis for excluding them, whatever computer program in the statute might mean. But that is as far as we go. My learned friend's, dare I say, sleight of hand yesterday was to suddenly say that the Comptroller accepts that the conventional meaning of computer is his conventional computer, and that this is an agreed position, and therefore not a promising start to be arguing for a construction which is contrary to the conventional meaning of the word. Now, that is not what we say. We do not accept, and have never accepted, that the conventional meaning of computer is limited to what my learned friend describes as a conventional computer. It is flat contrary to our case and inconsistent with the position reached by the Court of Appeal. Moreover, one only has to think of analog computers, which predated 1977, and quantum computers, which may or may not have predated 1977, to realise that these are also conventional uses of the term computer, albeit less popular. And neither has CPU or any other things that my learned friends were using to define conventional computer. Now, against that background, I now turn to the Court of Appeal's analysis. And Lord Justice Burst started by looking towards three specific principles of statutory construction to guide the court's decision. And we can pick those up in the judgment at paragraphs 59 to 60, which start on page 158. First, at paragraph 59, the court considered whether any of the preparatory works of the EPC or the 77 Act shed any light on the legislature's purpose for having the exclusions at all. And citing Lord Justice Jacob in Aerotel, the court noted that in this instance, people have gone and looked for preparatory materials for the exceptions, all of the exceptions, and have never found anything in the preparatory materials which is of any assistance on interpretation. And for my Lord's note, the relevant paragraphs of Aerotel, we don't need to go to them now, but they're pages 350 to 352 of the bundle, and it's paragraphs 8 to 12 of Aerotel. And we respectfully say that my learned friend's criticism that I'm not relying on preparatory materials as to the legislature's purpose is therefore misplaced. I'm not, but that's because all attempts to do so have failed, and they don't take us one way or another. The second point, at the end of paragraph 59 of the Court of Appeal's judgment, the Court of Appeal acknowledges that TRIPS requires that patents to be granted in all fields of technology. Now, my learned friends say this means that fields cannot be excluded, and appears to interpret this to mean that it follows that the field of neural networks cannot be excluded. But with respect to my learned friend, this takes us nowhere. As the Court of Appeal was at pains to point out, the field of neural networks is not excluded from patentability. They are treated in precisely the same way as other technical fields, and in particular, computer-implemented technologies. Now, it's common ground that the computer program as such exclusion applies to programs for conventional programmable computers. But no one is suggesting that this is incompatible with TRIPS. There is no reason for the EPC only to be compatible with TRIPS if it is somehow restricted to conventional computer programs. The TRIPS argument is unhelpful and doesn't distinguish between neural networks and other exclusions that may come under computer program. And we respectfully say, if anything, what one can take from TRIPS and the requirement for patentability for all fields of technology rather suggests a concept of equal treatment, rather than manufacturing distinctions between different types of computer, so that some new computing field, such as neural networks or quantum computing, or older fields, such as analog computers, are treated more or less favourably than the field of conventional computers. And the third point to which Lord Justice Burst directed himself was the principle considered by this court in News Corp Ireland and HMRC, and that is the always speaking rule as to how to interpret a statute from some time ago when technology has moved on. And the point which the Court of Appeal takes from that case is set out in paragraph 60 of the judgment, the point being that the meaning of a statutory expression does not change, whereas the class of things which it covers may do so. Something which did not exist when the Act was passed, and therefore could not have been identified as being within the Act at any time, may still be covered by the Act today, once its meaning has been understood. Now we say all the more so when neural networks did exist when the 1977 Act was enacted. Lord Justice Burse specifically mentions that the Mark I perceptron dates from the 1950s. It's just that artificial intelligence and neural networks are way more popular now than they were in 1977. And of course, we add also that analog computers were known in 1977. But yet, quantum computers were not. The application of news in Ireland would likely extend, we don't have to decide it for the purpose of this case, but would likely extend to quantum computers. No reason whatsoever to see those as excluded under the Act either. Now, against that, the Court of Appeal turned to construction or interpretation at paragraph 61 over on page 159. And Lord Justice Burse very shortly dealt with the meaning of computer, adopting a broad term without demur from either of the parties before him, namely, a computer is a machine which processes information. And as I have prefaced, it's not really the definition of a computer which especially matters, because it's not computers that are excluded by the provision. But if anything, it is implicit in Lord Justice Burse's reasoning and common ground before this court that insofar as one is seeking to construe computer in context, we at least mean it's a programmable machine which processes information, because only a programmable machine can have a program. Now, the essence of the Court of Appeal's construction as to program for a computer is then found in the remainder of paragraph 61. And with the assistance of dictionary definitions of computer program, and also looking to the previous treatment by the courts, or in paragraph 62 and 63, albeit that none of those cases were seeking to engage in a formal construction exercise, Lord Justice Burse holds that a computer program is a set of instructions for a computer to do something. Now, exactly how this plays out and the distinction between a computer and its program then comes in the final sentence of paragraph 61. The program is the set of instructions which cause the machine to process the information in that particular way rather than in another way. Taken as a whole, what Lord Justice Burse is saying is that a computer is a programmable machine for processing information.
The trouble is any inputs cause the machine to process information in one way rather than another. And it doesn't distinguish between inputs which are instructions and inputs which are just data.
My Lord, we say it does because the description is that it's the program that makes the computer act in a particular way rather than in another way to process that which is presented as input data. For a neural network set up, looking at it as to what it is and to how it's being used, there's no question of throwing bags of weights and biases at the network simultaneously with bags of input images and things, and just seeing what drops out at the end. Purposefully, what's going on here is that the neural network structure is taken, the instructions, the weights and biases, are presented once, so as to form a machine which performs a certain task, so that whatever data comes along, the input as data is processed in accordance with those instructions.
But the same then is true of all the aspects of the internal mechanics of the machine, the nodes and so forth.
Which are all configured by the biases and the weights, save for the issue of pruning, which we discussed yesterday, which is simply where the weights and biases go to zero. I mean, in many ways, my Lord, if you take the no way to distinguish between data which is program and data which is input, you can say the same of a normal computer program. The PC is sat on my desktop. I throw at it Microsoft's Word, and I throw at it what I'm typing in at the keyboard. Well, which is the program and which is the data? They're both inputs to the system, and there's no program at all. The reality is one has to take a step back. One has to look at the technology and has to understand what's going on. And the set of numbers, call it data if you like, in the broader sense, is presented for two different purposes. One, to configure the programmable architecture to set it up to do a certain task. And the second purpose is the data proper, which is the information that the programmed machine is going to operate on.
May I just leap ahead for a moment?
Yes,
Paragraph 68, first sentence. Do I understand your submission to be that that needs a qualification because it must have a programmable architecture?
My Lord, it is fair to say that if one was writing it with 20/20 hindsight, I think it's implicit that,
yes,
that Lord Justice Burst meant a programmable architecture, yes.
And you may submit that is inherent in his use of the term computer.
One ventures not to speculate as to what was in the mind of the judge below, but it seems to be implicit in what Lord Justice Burst was thinking. He didn't see a problem with electric filter circuit. He didn't see a problem with electric filter circuits and other such examples that my learned friends were submitting to the court at the time. He didn't consider that they came within what he meant to be a computer. And it's quite clear from considering that the computer needs a program that it was a programmable structure that Lord Justice Burst clearly had in mind. And in any event, it's resolved by the actual construction that was before him, which is what does a program for a computer mean? And obviously it means nothing if for those, that subset of computers, if there were one, that aren't themselves programmable.
How far does this go? I think you gave us an example of something that would fall outside this definition, the timing gadget on a toaster. Mm-hmm. But most toasters, except some probably very crude ones, have a knob on them where you can set the amount of time at which it turns off the power. But why isn't that a programmable computer?
Because that is a user input.
Oh, I see. So programming has to be somebody other than the end user.
Yes.
Right.
That's one way of looking at it. But the input into that mechanical timer is the knob that one is turning. But that mechanical timer is always a mechanical timer. I can give you a contradistinction, which is that I could implement my toaster's timer using a microprocessor. And I could have a program that read the input dial, set up a timer, counted down against the clock crystal, and turned the output on and off. Now, the function's the same, but that is now a program, a computer with a computer program. And if I wanted to, I could take that microprocessor out and reprogram it to repurpose it to do some other task.
It's a curiosity that these...
Similar to every single oven, basically.
Similar
to every single oven.
Yes, exactly. And we're all familiar today with the fact that ovens almost certainly don't have electromechanical timers in. They have displays and timing circuitries, and these days they can connect to the internet so that you can set them going before you leave court. But yes, the function, the overall application isn't what dictates it. It's the architecture and how things are implemented.
And it would be excluded under as being technical. Wouldn't fall within.
They would engage the exclusion, but the likelihood is when built in to an overall product, if the claim was to an oven wherein it does various things or whatever, it's likely that the exclusion would be would fall away because there would be something technical going on. The problem comes when you try to focus on just the computer and the program itself without a computer implemented invention.
It's a curiosity that these puzzles at the edge of the meaning of the term that we're presenting to you are at the simplistic end, whereas we're considering here an "and," which is right at the other end of the scale of complexity. And because there may be difficulties at one end, doesn't necessarily mean it's a reason to exclude an even more complicated system than a conventional computer from the scope of the term.
Well, quite, my lord. And what tends to go on, I think, when we're looking at electromechanical timers and things, one's trying to find a silly example that no one standing back and looking at it properly would say is a computer with a computer program, and using that by then taking the neural networks and assuming that one would try and implement them with a whole bunch of carefully calibrated values of resistors. Nobody in reality is ever going to do that.
But the reason we're all doing that is because we're all testing the first sentence of the Court of Appeal's paragraph 68.
68. Yes, my lord.
We're saying, can we think of a reductio absurdum that shows it can't be as simple as that?
And the point that I was making with my first observation is we make our job an awful lot easier by focusing on a program for a computer, which is the statutory words, rather than perhaps a very broad definition of computer.
I mean, I don't think it matters, but because of the point you make, but processing information sounds pretty broad to me. You might have thought that the idea of computation or computing might come into the definition of a computer, which is one way of processing information.
It is. But we would say even if you did go down that way,
it won't affect your analysis.
It wouldn't affect my analysis.
Because obviously these machines do compute. And that.
Exactly. Exactly. Now, there is one further point to pick up on this, is in paragraph 67. And Lord Justice Peirce is considering here a topic which we touched on earlier, which is the permanently programmed computer, such as a dishwasher. And here Lord Justice Peirce acknowledges that washing machines and payment cards and the like have programs which cannot be changed, at least by the end user. But there remains a meaningful distinction between the computer itself and the program. He emphasises that the computer is the unprogrammed hardware which doesn't perform any particular function, and the program, permanent or not, is the set of instructions which cause the computer to perform a particular task. This is where Lord Justice Peirce cross-refers to the decision in Gale that's simply making a program permanent, for example, in a read-only memory, doesn't avoid the exclusion. I mean, put simply, a program is still a program, no matter how permanent it might be. At paragraph 64 to 66, the Court of Appeal addresses my learned friends' then arguments as to why computer or computer programs should be construed to exclude neural networks. And in each case, the attempt is to try to find something about a neural network which is different from a conventional computer program, to force a distinction which is nowhere to be found in the Act. At paragraph 67, the Court addresses specifically the activity of the programmer, but as we have discussed, there's still a person who trains the neural network, and Lord Justice Peirce points out, quite rightly, that the precise role of the person's input leading to the computer program always differs depending on what programming environment is being used. And in any event, it's almost never the case that the so-called programmer is actually writing the machine code which the computer ultimately uses. And we touched on both of those points in some detail earlier. At paragraph 65, Lord Justice Peirce considers the types of problems to which neural networks are best suited, but points out quite shortly, again as we've discussed, that the same arguments can apply to conventional computer programs. Neural networks can be very simple, with a network of only a small number of neurons and can be trained to do very simple tasks. Size and complexity of the problem or architecture cannot properly be a distinction. And although Lord Justice Peirce does not go back to the principles which he said he found helpful at the outset, what is implicit in his reasoning, and clear we say on a moment's thought, is that the construction which the Court of Appeal has reached on programme for a computer applies sensibly and reasonably to anything one might reasonably consider to be a computer programme. My learned friends, conventional computers, such as a modern PC, or at the other end of the spectrum, embedded computers in dishwashers. There's the generic computer hardware, then there are the programs, either including the operating system, and in each case we load them to make them do a particular task. Analog computers, which are programmed using removable program panels of connections and gain settings. You remove one panel and replace it with another, changing the processing which will be performed, making the underlying hardware do different specific things. And my learned friends simply ignore these analog computers, which existed in 1977. Are they in the definition or out? If they're outside of the definition, then why?
Is there some familiar example of an analog computer which will shine a light into my mind as to what they really mean, save that they're not digital?
Not in the papers, I'm afraid, my lord.
No. But never mind whether they're in the papers or not. I mean, what is an analog computer? It's just one that isn't digital, isn't it?
Yeah, so an analog computer, if I may, my lords, an analog computer were predominantly used for things like solving differential equations, where, for example, the output is the integral of the input times a gain and with feedback. And what you used to do was build an amplifier that was a generic integrator, and then you would put an electrical signal in representing your number base. It would electronically integrate and you would get an analog output. You could also differentiate by arranging an amplifier to find the gradient of the electronic circuit, and you had these generic cells that could integrate, differentiate, or just multiply with a gain, and you'd have a massive panel of them, and you would wire up line 1, your first differential function, line 2, your second differential function, line 3, and as far as they were cross-connected, so one differential function was feeding into another, you could feed the output to the input, and then you just ran the computer for your given input, and you got a nice graph or oscilloscope trace or whatever coming out the other end, which would give you the equivalent of sending a rocket on a trajectory or whatever it might be. And they were used for decades prior to 1977, before we moved on and had sufficient computing power in digital computers to program the issue digitally and do the same exercise, but by multiplying numbers through in matrices and things of that nature. But these were done back decades ago, when we didn't have enough digital computing power, but we could make very good analog amplifiers for different problems. Now,
analog computers using electrical or mechanical means, they also had to be programmed. And was that physically, in the sense of some programmer setting up how the electrical currents or the mechanical response was to take place?
They were done by patch panels that would patch the inputs and outputs and gain settings for the entire analog machine.
Yeah.
And because the amplifier sets were expensive, you would have individual patch panels that were large things with handles on, and you would unplug one program and put it aside and grab one that you made earlier for some other set of calculations and plug that into the machine with all the connections set up by the programmer, and it would then run that set of calculations.
So that was a setup of a mechanical setup, was it?
It's electrical wires.
Electrical wires.
And resistors and the like, yeah.
And resistors and the like.
Yeah.
And So it could also be described as a box containing electronics.
Everything that's electronic can
Yeah.
ultimately be described as a box containing electronics. But the point, the distinction is that you've got the generic machine. You could buy your analog computer from whoever was producing your analog computers, and then I can set it up to do the calculations my company wants to do. Whereas my learned co-counsel might have a completely different farmer calculation she wants to do, and she would set up the same computer bought from the same company to run a different set of
I was just
equations.
trying to see what the difference between attaching weights and biases to in an ANN and attaching mechanical electrical currents in an analog computer is.
The analogy is very, very close. The ANN is much closer to an analog computer than what we are familiar with as a digital computer as such.
Yeah.
But it doesn't end there. The modern world is coming, and I think it's right for me to work on the basis of post-1977. We have quantum computers. Now, quantum computers don't have the architectural characteristics of a conventional computer. My learned friend rightly knows that they don't, but yet just a quick search on the internet shows that Microsoft has a high-level programming language for quantum computing called Q#. IBM has one called QuizKit, spelled QISKIT, and Google has one called Cirq, spelled CIRQ. Now, my learned friends haven't made their position clear whether quantum computers are within a fair construction of the provision or not. We say they clearly are. The same characteristics are there: a programmable architecture and an environment which allows a skilled programmer to set that environment up to perform a specific task. And we respectfully say that taking the Court of Appeals construction, we have something that works well, catches that which you would expect to catch, and excludes that, such as mechanical timers on toasters or electromechanical jukeboxes, that neither side contend ought to fall within the exception. So, contrary to the unparticularised assertions, largely from the interveners, but also from my learned friend, the contention that the Court of Appeals construction significantly broadens the scope of the exclusion from patentability, that's the intervener's paragraph 2.3, we cannot begin to see why that would be so, nor do we find a single example given as to how that would arise once one properly focuses on the Court of Appeals construction of programme for a computer rather than simply computer. Now, my lords then have the application to neural networks starting at paragraph 68. And my lords will be familiar now with paragraphs 14 to 15 of the judgment, and the court's finding that to convert a naive ANN, call it machine A, into an ANN which can perform a useful task, one doesn't need to train the particular ANN machine A. One can simply transfer into it adjustable parameters derived from the training of another ANN machine B of the same kind. And I touched on what we mean by the same kind yesterday, in the same way that normal computer software, what you've written for an 8-bit machine, isn't going to run on the hardware of a 32-bit machine without more. You do need the architectural structure to be the same. You need enough nodes, you need enough layers to be able to run the program for that architecture. Now, the correct and unchallenged, from that correct and unchallenged technical finding, together with the Court of Appeals construction of program for a computer, we respectfully say that the court's conclusion at paragraph 68 naturally follows. An ANN is clearly a computer. It's a machine for processing information. We would say, insofar as one tries to narrow that down and say a programmable machine for processing information, same.
But more importantly, it is the sets of weights and biases that are a computer program. They're the set of instructions which cause the computer to do a particular task or fulfill a particular purpose. In the middle of paragraph 68, Lord Justice Burrs touches briefly on the fact that the instructions are in a different form to those needed for a conventional computer, but he rightly says that this is irrelevant. There's nothing in the statute and no reason to imply anything about a particular computational architecture. And we touched upon earlier, and I've already addressed your lordships, as to my learned friend's attempts to say that the weights don't tell the computer how to process the data. We say that simply isn't true. Without knowing which weight goes on which branch, you don't know what to do when the input data gets to that branch. Lord Justice Burrs also at paragraph 69 points out that the EPO has no hesitation in considering that the computer program exclusion applies to neural networks. And the judge cites by way of Mitsubishi in this respect and actually picks out and says in terms, the board held explicitly that a neural network relates to both programs for computers and to mathematical methods. Now, my learned friends yesterday sought to take that passage and say it wasn't quite as clear as this, because when you look at Mitsubishi, there was a computer involved as well as the ANN. But the important point is that neither my learned friends nor the interveners have produced a single case from the EPO or any other EPC contracting state where any court has even hinted, let alone come to the conclusion that computer programs, that artificial neural networks are not computer programs. Now,
aren't computers?
Aren't computers, don't involve.
Well, they're neither computers nor computer programs,
Right.
but they, you say they involve computer programs.
Exactly, my lord. Just like the UK, the EPO considers that both the computer program and the mathematical method exclusions are engaged by neural networks and neural network implemented inventions. Now, as it happens, and I don't shy from this, the EPO prefers to lead with mathematical method, and the UK, we tend to lead with program for a computer. Now, frankly, we say it doesn't really matter which exclusion one prefers. Both generally apply to a neural network, and then either one or the combination of both can lead to the patent application being unpatentable.
May I ask you, just in a few sentences, if you'd be so kind for my benefit, to elaborate the basis of the mathematical method application in this context?
Yeah. I've lost it. Figure 6 is always a good touchstone because we can see what we are looking at. It's on page 222 of the bundle. And you can actually write the entirety of a neural network out as a complex mathematical function. You just take the input x, times it by wi, sum it up with the rest of the ones going into that node times bi, operated by the mathematical function f. That then becomes the input to the next stage, and you add on the same weights and maths, and you can end up with a huge, great, abstract mathematical equation for the whole of a neural network. And you can do that either completely abstract, where you haven't set the weights and biases, or for any given system, you can put the numbers in when you've got them.
Yeah. The fact you can describe it in purely mathematical terms doesn't answer the question, does it?
No.
That's just a gateway.
So it's a gateway, it's a starting point, and then that takes us into exactly the same way, that simply claiming I've used the mathematical method of a neural network to solve this problem. Simply asserting that, the EPO takes the view, well, that's just, you can't just say, I claim a system to solve this problem involving this mathematical method, end of claim. Because at that stage, all you've claimed is this arbitrary, disconnected mathematical method, in the same way that if I said, I claim a system to solve this business problem using a computer. I've got a business method in there and I've got a computer in there, and hang on a minute, where's the patentable subject matter? In exactly the same way as computer implemented inventions, once the exclusion has become applicable, one then has to start looking at the claim as a whole and saying, is it wholly within the exclusion, or have I done something to take it out of the exclusion? So just in the same way that with computer implemented inventions, just because I've got a computer, it doesn't mean you can't patent it. I have to look, is that computer running a better machine for a canning factory, or am I just claiming a computer program doing nothing save within itself? And the same with the neural network. If I claim a neural network, I'm in a mathematical method, but I have to use the same test. In the EPO, it's any hardware plus convict. In the UK, it's Aerotel, to look for the technical contribution outside of the excluded subject matter.
Well, you'll no doubt come to that, because that, I understand it, is exactly the case that's put against you, that there is something.
Well, indeed, we say on mathematical method, in this case, the case has progressed through on the basis that computer program was the leading exclusion. And that was enough to take the neural network out of contribution. Careful of the language I use, because you've got to be careful how you do that. And then you go looking for, is there anything else to save the claim? And it would be exactly the same if you took the neural network out because it was a pure mathematical model. You still end up, a mathematical method, you still end up looking for the same technical contribution elsewhere from the claim as a whole.
All the way the two relate together?
All the way the two relate together, which is also possible. But in this case, in this particular application, what happens is the neural network falls away and you're now left looking for something in the overall system. Now, my learned friend, Dr. Edward Stewart, will deal with this in more detail, but when it went through the EPO, the mathematical method was taken out, and what was left, and the analysis left, was exactly the same analysis as the Court of Appeal had to do here. And what actually happened in this case is that my learned friend says the decision by the hearing officer below in paragraph 78 means that he's already won on the mathematical method. But that isn't actually the complete story. You have the hearing officer's decision in the core bundle on page 211, gone to the middle of it. And what's actually quite important is paragraphs 62 and 63. And what the hearing officer actually decided in paragraph 63 is that I'm not persuaded that the neural network can be decoupled from the software platform that supports it in the way Mr. Chacksfield suggests. Even if it can, it's important to consider what an ANN is at the level of generality. It's an abstract model which takes numerical input, applies a series of mathematical operations, and so on. The claim to an ANN, or the algorithm by which it's trained, in general and abstract sense, relates wholly to a mathematical method, and it fails at step 3. Even if there's something more than a mathematical method present, I can't see how this is technical in nature and it would satisfy step 4. What my learned friend likes is paragraph 78. On the issue of exclusion as a mathematical method, although the ANN and the method of training an ANN is per se no more than an abstract mathematical algorithm, its specific application here as part of the file recommendation engine is, in my opinion, enough to dispense with the mathematical method as such objection. And what happened there is my learned friend, is that the hearing officer
rejected the applicant's software decoupling point and found the claims to be excluded under the computer program exclusion. The difficulty is, if my learned friend is right and the computer program exclusion doesn't apply, then one has to consider again mathematical method. Now that's why it was taken as ground 3 to the Court of Appeal. And it's why Lord Justice Burr said, even if we're wrong as to computer program, final paragraph of the judgment, it seems to us that the mathematical method would apply instead. Now,
I think he said might well apply or something like that. I don't think he made a conclusion on it.
Your Lordships are right. It's an obiter, a strong obiter indication in that there's no need to consider this aspect of the appeal. I will only say that I think this objection might well have had traction if the conclusion that the ANN was not a computer program. Hard to see why, even if they were not to be regarded as a computer program for some reason, they're not in any case a mathematical method. And so the very same analysis based on Aerotel approach would apply with the same result. And then notes Mitsubishi. And what we say in this case is, look, we've served effectively respondent's notice in the way that one does in this court as to the mathematical method. And even if my learned friend succeeds on issue 2, he needs to deal with his questions 3 and 4 as to the application of Aerotel to the mathematical method as well. And at the moment, he hasn't even attempted to do so. Now, your Lordships may feel that you haven't seen enough of the mathematical method to actually deal with that, and that my learned friend hadn't realised that the issue was still live, and that when this goes back, if it's to go back for further prosecution, which is obviously necessary to the Intellectual Property Office, it would be considered there together with any guidance from this court.
But is the analysis going to be different, or is it, as Justice Burr suggested, going to be the same, or effectively the same?
Well, we say it's the same, so your Lordships would be able to deal with it. But if your Lordships don't need to deal with questions 3 and 4, because you say either Aerotel doesn't apply, or your Lordships hold that the computer program exemption doesn't apply to neural networks, we respectfully say that when mathematical model has always been around in the background, the one thing that can't happen is that my learned friend gets a free pass and we allow an invalid patent that would never have been allowed in the EPO, simply because mathematical method has been limping in the background through the course of these proceedings.
Well, I took him to submit that the mathematical method, we can decide that it doesn't apply. I mean, that was his argument. I mean, he was engaging with it. I don't think it's true to say he was brushing it aside. He may be wrong, but he was making a submission that we can say plainly that it doesn't apply.
It comes to the same issue. Once you say the mathematical method, nobody has ever said in the EPO or otherwise that ANNs are not mathematical methods, and I didn't understand my learned friend to be arguing that they weren't. So the moment that the mathematical method is engaged, my learned friend has to go through the Aerotel questions as to what happens if you remove the mathematical method as such contribution from the claim. You've got to be looking for something technical remaining in the claim that isn't wholly excluded subject matter. And the EPO's position, and my learned friend Dr. Edward Stewart will show you that in more detail, but also Lord Justice Burse's consideration was that when the mathematical method exclusion comes up, my learned friend finds himself in the same problem of having to get through Aerotel. It's not... Well,
unless he's getting through convict rather than Aerotel.
Exactly. Yeah.
But I imagine you're going to come on and say, well, that doesn't get him out of the thicket.
That's exactly what the EPO did, and they threw the patent out at the preliminary stages for exactly the same reasoning when you go down the any hardware plus convict route. So, my lords, unless I can assist further on that statutory question, that moves me on to issue 1, which is the procedure for applying the exclusions.
And I don't think that anyone who has had to actually grapple with applying any of the various and disparate exclusions as such, provisions of the EPC or the 77 Act, would suggest that they are easy to apply. They're not. But the IPO and the EPO and the courts have been doing it for almost 50 years. And it's fair to say that deciding how to go, that in the process of deciding how to go about the exercise, it hasn't always been plain sailing in harmonious waters. To the contrary, and perhaps regrettably, over the years, the EPO and at least the UK courts have on occasions been less than complimentary about each other's various attempts. But we're a long way past that. As we've set out in our written case, poring over first instance or even appeal authorities from the last 50 years is not especially helpful. Things have changed and moved on in both fora as time and learning have moved on. And as my Lord Briggs opened to both council with at the beginning of yesterday, terms such as contribution and technical have changed considerably over time. And great care has to be taken when looking at the older authorities to make sure that one's still talking about the same thing or the same concept as the newer authorities. And we respectfully say we've arrived at a point of real stability where the current approach of the EPO is well settled and well understood and has been endorsed by the enlarged Board of Appeal. And the current approach in the UK is also well settled and well understood. And my client's position is that the two approaches, the details of which I'll come to, have the same substantive effect. They apply the same substantive law, but they do so by way of somewhat different procedures. But nothing requires the procedures for applying the EPC to be harmonised. The EPC does not even seek to lay down procedural rules. Rather, the EPO and the UK and all other EPC contracting states are entitled to take whatever procedural approach best suits their overall system in their jurisdiction. And it's common ground that the other EPC contracting states, as well as the European Union's new Unified Patents Court, take procedurally different approaches to the exclusions. But they do also to other important areas of patent law. Properly understood, and as my learned friends finally accepted yesterday with their hand up, it's not possible for the UK to simply adopt the EPO's approach to the exclusions without also making major changes to other core areas of patent procedure in the United Kingdom, most notably the assessment of inventive step. And finally, adopting the EPO procedure on the exclusions cannot be done without effectively prohibiting the Comptroller's ability to use the express statutory power given to the Comptroller under Section 17(5)(b) of the 1977 Act. I'll obviously come on to that. It follows that there's no need for the EPO's approach to be adopted by the Comptroller in the UK courts. And more than that, it would be harmful to the UK's procedural approaches to patents generally and to try to partially harmonise procedures on excluded subject matter. Now, I'll go through these points and make them good, but the present appeal has a much bigger issue, which is what the appellant is asking this court to do instead. It is not asking this court to adopt any hardware plus convict. It's asking for what we have called a Frankenstein test, trying to mix parts of the EPO's approach with parts of the UK approach.
So what did you call it?
A Frankenstein test.
Oh, Frankenstein, yeah.
This doesn't achieve anything useful. It's simply an attempt to write out the exclusions entirely. It's wrong in principle and has previously been expressly rejected by the UK courts as a familiar and illegitimate approach.
Well, I certainly understood them to be inviting us to adopt the EPO approach.
Well,
not some hybrid.
Well, what they handed up to you, my lord, was not EP plus any hardware plus convict. What my learned friends want is any hardware plus pot solely is what they say in their written case. They've now realised that any hardware
plus Pozzoli basically renders the exclusions completely nugatory and is at absolute odds with the EPO's approach. So they now suggest EPO plus modified Pozzoli. Pozzoli being the inventive step assessment that is routinely used in these courts. And when the Supreme Court was asked in Actavis and ICOS 2019 to mandate use of the EPO's problem solution approach instead of Pozzoli, this court rejected that submission, saying it was up to the UK courts, if they wished to continue to use Pozzoli, they could do so. Now, my learned friends have thrown that all away, and they've realised that Pozzoli is incompatible with the any hardware part of the test that they like, exactly as His Honour, as Mr. Justice Bruce, I think it was, His Honour Judge Bruce, as he then was, said in Halliburton, you can't take the first half of the EPO test and mix it with the UK's inventive step test. So that's why my learned friend very belatedly, and at the end of yesterday afternoon and then overnight, handed up his 2B rider, which is supposed to be a modification to the UK's approach to Pozzoli. I'll come on to the detail of that. It's an absolute nonsense. So
the first thing is that there's a Supreme Court decision approving Pozzoli.
Yes,
is that right?
Lord.
And I'd like to have the reference for that.
Your Lordship,
and the actual paragraph.
Yes, it's Actavis and ICOS. I'll find the actual, reference.
And secondly, you're correct. He was putting forward 2A to be inserted into the Pozzoli test, yes, which in some ways seems to be a mixture of Pozzoli and Convic, and but yet didn't demonstrate in any sense at all how that would operate in practice in this case.
Absolutely, my Lord.
You're going to come back to that, are you?
I will obviously come back to the detail of it, but I do say one has to keep a very, very firm eye on what the appellant is actually asking this court to do.
Well, if he's asking us to overturn a previous decision of the Supreme Court, he should have said so.
Well, quite. And we respectfully, I'll come to the detail, but I respectfully say not putting up, acknowledging that you need to change Pozzoli, but not putting up a concrete test that can be applied by the Comptroller, my client, and applied in the courts, but instead amounts merely to some guidance that you ought to try and be a bit more EPO about it, is just a recipe for disaster. It's just going to be a gift to the lawyers that has every case. And we're not just talking about exclusion cases. Pozzoli is used for inventive step. The same construction as is used in the Pozzoli step is used for infringement, something the EPO doesn't have to deal with. You're talking about almost every patent case having to work out what this new test is from the bit of paper that my learned friends handed up. And we respectfully say we are a million miles away from having a proper contender alternative before this court, before it jettisons Aerotel.
You will, presumably at some stage, tell us why it's impossible simply to apply any hardware plus Convic. Because that seems to be what the combined, the enlarged board has blessed.
Your Lordship's right, I will come to that. The short answer is that Convic is the is a modified version of the problem solution approach. And the problem solution approach is what this court in Actavis and ICOS chose not to prefer over Pozzoli. And I'll come on to the details and you'll be able to see why in a moment.
I think that may be important because of the way the cases develop in these different, either before the EPO or before a national court in an infringement or revocation case.
I'm grateful, my Lord. So let's just look quickly at what the EPO's test of any hardware plus Convic is. Your Lordships will have appreciated that the test is, as adopted by the enlarged Board of Appeal in Pedestrian Simulation, G119. Now, the essential feature of the EPO approach and how it differs from the UK
is that it actually looks at excluded subject matter twice. This was explained by the Technical Board of Appeal in Mitsubishi in 2022, applying the law as stated by the enlarged board in pedestrian simulation, which came in the previous year. And we can pick this up in our pages 96 to 97 of our written case, at paragraphs 51 to 54. And at paragraph 11.1, which is quoted at the top of page 97, the court refers to pedestrian simulation and explains that in the first step, it's assessed whether there is an invention in the meaning of Article 52.1 in view of the exclusions in Article 52.2 by the so-called any hardware approach. Now, it's considered that an invention is something that possesses technical character and that this condition, that's the requirement of the Article 52, is fulfilled the moment any technical means, e.g. a computer, is claimed. So the first step is a very simple assessment in which doesn't even consider whether we're worried about the business method exclusion, the mathematical model exclusion, computer programs or aesthetic creations. The moment we say some bit of hardware in the claim, one passes the test. But the court then goes on to explain what it calls the second step. In the second step, the so-called COMVIC approach, it is made sure that only features contributing to the technical character of the invention are considered for the assessment of, in particular, inventive step. In particular, non-technical features, understood in this context as features which on their own would fall within a field excluded from patentability under Article 52 EPC. And just pausing there, that's the way EPO uses technical, excluded or not excluded subject matter, can only be considered for the assessment if they contribute to solving the technical problem. Even technical features may be ignored with regard to inventive step if they don't contribute towards solving a technical problem. And what we therefore see is that the excluded matter from Article 52.2 is considered twice. First, in the easy to pass any hardware test, but second, in formulating the relevant considerations when approaching inventive step. Now, this second consideration is COMVIC, and we need to take this in two parts because the enlarged Board of Appeal in pedestrian simulation, which was quoted on page 96 of our written case, sets out our paragraph 52, the normal inventive step test used, the problem solution. Firstly, you determine the closest prior art. Secondly, you assess the technical results or effect achieved by the claimed invention when compared to the closest prior art. Thirdly, you define a technical problem to be solved, the object of the invention being to achieve the results, and then consider whether or not the claimed solution, starting from the closest piece of prior art and the objective problem, would have been obvious to the skilled person. And that's the unmodified test. Now, we can then pick up what the EBA said about the two-hurdle approach in our written case at page 103. In the third quoted paragraph on the page, which has actually got a typo in, it's paragraph 39, not 29. The court says the two-hurdle approach, the first hurdle of which is the any hardware, the two-hurdle approach for computer-implemented inventions actually entails three steps: establishing whether a feature contributes to the technical character of the invention constitutes an intermediate step between assessing, one, the invention's eligibility under Article 52, and two, whether the invention based on an inventive step vis-à-vis the closest prior art. This additional intermediate step serves as a filter for features contributing to a technical solution of a technical problem in view of the closest prior art. Only those distinguishing features can contribute to inventive step. And just breaking that down, there's thus three steps. Firstly, is there any hardware in the claim? Secondly, identify or filter the distinguishing features which contribute to the technical solution of the claim. And then thirdly, apply the conventional problem-solution approach. And it's this additional filter step which distinguishes convict's modified problem solution from the normal problem solution. And importantly, the way one applies convict is that when assembling the problem solution, the whole of the claim is maintained. But the excluded subject matter, and this is quite important, the excluded subject matter is moved from the solution part of the problem, part of this test, to the problem part of the test. Now, that does two things.
Sorry,
First,
moved from what part? Sorry?
move from the solution to the problem.
Can you give us an illustration of that in colloquial terms so that one can see how it works? Otherwise, it's
In abstract.
not easy to envisage.
But someone who doesn't work with problem solution all the time, I'll have a think about it and I'll see if I can come back with a simple example. But it has two effects. Firstly, because you continue to look at the problem solution as a pair, all of the features of the claim remain present. But secondly, those that were excluded subject matter, because they're in the problem and not in the solution, they aren't permitted to contribute to the inventive step. They're taken as known. They're taken as the skilled person's starting point. Now, that brings me on to the error-tell approach, so we can compare and contrast them. The fundamental procedural difference between the UK's error-tell approach is that it considers and determines excluded subject matter under Article 52 as a self-contained exercise without mixing it up with the determination of inventive step under Article 56. Now, the four-step process is in our written case at paragraph 55 on page 97. We properly construe the claim. We identify the actual contribution. We ask whether the actual contribution falls solely within excluded subject matter, and then we check whether what remains is actually technical in nature. There's a further rider to step 2, which is discussed on the quoted section from error-tell at paragraph 44 over the page. It points out that during prosecution, because the IPO has yet to determine what the applicant has actually contributed, hasn't been able to do inventive step yet, it might be necessary to proceed with what the applicant alleges he has contributed on a pro tem basis. Now, as we can see, the test requires looking at the claim as a whole, inevitably so, including the excluded subject matter, and then asking what has been contributed, what is new, as the Court of Appeal held in error-tell at paragraph 43. What has the inventor really added to human knowledge perhaps best sums up the exercise? Now, we haven't even mentioned the exclusions at this step in determining the contribution. There's no consideration of the prior art. Contrary to all the complaints of my learned friends of saying, trying to pick up one side of the argument from Duns in the EPO at a time when the courts were busy disagreeing with each other, there is no suggestion that anything relevant might have been excluded when the actual contribution is determined. Indeed, the test specifically allows, in the event of dispute, for the test to proceed on alleged contribution, even though the examiner may feel or be in some doubt as to whether or not something can safely be dropped at this stage. Now, in reality, and we'll see this when we look at some specific examples, and the appellant's application in particular, what gets dropped at this actual contribution stage is generally pretty limited and is based on the examiner's knowledge and experience. It's things like over the internet, using a database or the like, which don't appear to interact and are entirely commonplace. As the examiner in the EPO said in the parallel case, technical arrangements such as a system, a database, communication network or so on, whilst undoubtedly technical, they refer to arrangements which are considered notorious to the person skilled in the art in the field of computer assistance. What we then ask in our question 3 is there anything in that contribution that's not excluded subject matter? Question 3 is limited to the specific exclusions, and will decide virtually every case. And we know of no actual examples where question 3, properly applied, is not determinative. However, question 4 is needed, as the Court of Appeal in Aerotel noted. It's needed for at least 2 reasons, both of which were touched on yesterday with my learned friends. First, Article 52.2 is not a closed list. It's by way of example only. So we do need, at least in theory, to consider whether anything has slipped through that perhaps requires more thought than just ticking off each of the items in the Article 52 list. And secondly, and in a very similar vein, Article 52.1 needs to be in a field of technology. Again, examples do not abound, but we have to allow for the possibility that an issue might arise.
I had thought, maybe wrongly, that the application of Aerotel Stage 4 could reinstitute a claim where the contribution fell within an excluded subject matter, but was nonetheless technical.
Oh, I think it's a further restriction, isn't it?
I think my Lord Leggett is right that it is actually a further restriction, a further hurdle one has to go through.
Right.
Because the question of question 3 is it solely excluded subject matter? If you had something at question 3 that wasn't excluded, then that's what you're looking for. That's your pass. It's only if you think you've eliminated everything from the excluded list and you think you've passed at stage 3, you need to take a bit of a look at what you're left with and say, hang on a minute, having gone through the list of exclusions, this thing that's left, is it perhaps non-technical in 52.1 or is it perhaps in the broader scope of 52.2? But nobody's aware of that situation ever arising, but that's what it's there for. And it needs to stay for that purpose. But it's not suddenly making the UK's test more restricted. Applications aren't being thrown out on the 4th question. We're not sure we can find an example of the 4th question ever being used to reject an application. And my learned friends seem to have no answer to the fact that there might be some cases caught by step 4 that don't get picked up by step 3. Now, the whole Aerotel approach ensures that the invention is considered as a whole, irrespective of the exclusions, and then the exclusions are applied to what is found to be the appellant's contribution or alleged contribution. There is no risk of salami slicing or mixing up prior art with the analysis. The claim is considered in full before we even reach the exclusions. It is actually the antithesis of the Genentech approach, which goes back all the way back to the very earliest days and was disfavoured and replaced by Aerotel. In Genentech, you took the claim and you went through with your blue pencil and crossed through excluded subject matter. And that was problematic because it led to missing interactions, for example. And the whole approach in Aerotel addresses that problem. All that happens is that there is a discretion to the examiner to focus on what really matters, notwithstanding that it has not yet assessed the inventive step, dropping out notorious material which doesn't interact or assist the contribution. But even that is backed with a safeguard that if in doubt, the alleged contribution should be used and the disputed matter as to inventive step can be sorted out later.
That's important because that means the patentee has the benefit of the doubt at that stage if there's an issue.
And if you want to say, no, I absolutely insist on keeping the computer, I think the computer's new, I don't recognise computers, you can say, fine, I was going to take the computer out because it seemed to be commonplace. You carry on all the way through. The only thing that's left saving your claim is the computer. The moment you get to inventive step, then that computer is going to be not convey novelty or certainly not going to have inventive step. So it gets closed out at the end. But your Lordship is absolutely right that the alleged contribution stops any issue of removing stuff when the applicant is saying, no, you really do need to keep this in before you do the exclusions. So any substantive difference between the two tests, we pick this up at paragraph 60 on page 99 of our written case. We're not aware of any cases which have shown a material substantive difference between the EPO's approach under any hardware plus convict and the UK's approach under Aerotel. Over on page 100, we refer to a number of the leading UK cases which have repeatedly found that although the procedural approaches are different, there's no reason to think that the EPO will hold a claim allowable when the UK court would reject it, and vice versa. And that takes us back in our written case, page 95, at paragraph 50, to what Lord Justice Burst stated in the decision below as being the consistent principle before both the EPO and the UK courts, that an inventor must make a contribution to the art. That's to say, must be new and not obvious, and that contribution must be technical in nature, in other words, susceptible to industrial application and not within one of the areas excluded by Article 52. And points out that was, we point out, I think Lord Justice Burst pointed out that originated from my Lord Kitchen at first instance back in 2006.
So what paragraph number, sorry?
Sorry, I'm looking in my paragraph 50.
Yeah, okay.
Quoting from Lord Justice Burst. We say both tests look at the totality of the applicant's actual contribution and require it to be technical and not wholly within excluded subject matter. Now, there is the slight oddity, which we directly address at paragraphs 62 to 66 on page 101 of our written case, which is in the UK applying Aerotel to a claim which consists of excluded subject matter. It will be rejected for reason of excluded subject matter under Article 52. However, in the EPO, because of the any hardware test, is deemed to satisfy Article 52, but the exclusions are engaged again on inventive step, Article 56. The same claim will fail, but it will do so for lack of inventive step under Article 56. And we take the example of a hypothetical mug with a creative image. In the UK, the actual contribution is just the creative image, but that's an aesthetic creation under Article 52(2)b, and we would reject the claim for reason of excluded subject matter under Article 52. In the EPO, the mug is any hardware, so Article 52 is satisfied, and the assessment then goes on to convict, but the creative image, and this is the example, I want to put an image on a mug, but you, instead of saying, and the answer is this creative image, you say, I want to put this creative. The problem is I want to put this creative image on a mug. And then you're left with no contribution to the solution. It's not allowed to form part of the solution because it's excluded subject matter. So we assess the known mug, which doesn't involve an inventive step, and the claim fails for inventive step under Article 56. Now, over the page at paragraph 66, we give a similar hypothetical example closer to home of a computer program on a floppy disk, but it has the same process. And at paragraph 65, whilst we do not think there's a substantive difference, we respectfully say that the Aerotel approach is actually perhaps more logical. The known mug with a created image is not unpatentable because it lacks non-obvious insight. It is unpatentable because the non-obvious insight is the creative image, which is wholly within the aesthetics creation exclusion. But even pausing for thought as one must do in this complex area, and considering matters from the other side, one could equally say, well, patents are only granted for technical things, and the only technical thing in the claim is the cup, and that doesn't involve an inventive step. And we rather fear, at this stage, academically interesting though the debate is, we're rather counting angels dancing on the heads of a pin. It's simply a question of how you look at it. One person sees a vase, another person sees a face. Overall, it is worth bearing in mind that it's Article 52.1 that matters. Neither Article 52.2 or Article 56 are ever the deciding article. It's Article 52.1 that requires all of the below provisions to apply. And my learned friend tried to say there was an element of structure to the Act here, but he needs to be a little bit careful, because the way that Article 52 2 on page 1454, the way that Article 52 works is subparagraph 1 looks like it's entirely complete, but subarticle 2 says the following shall not be regarded as inventions within the meaning of paragraph 1. So actually, to understand what the definition of paragraph 1 is, you have to read subparagraph 2. And the point actually becomes even clearer when you see how our legislature implemented it over on page 1460. And my learned friend stumbled slightly at subparagraph D, because we've added the exclusions into the same stage rather than splitting it over two subsections, where you can be led to believe that you can construe Article 52.1 without taking account of 52.2. But of course,
but surely it is structured so that it's saying that something isn't an invention, and that links up to the word invention in the opening words of 1.1.
exactly.
Before you get to the additional requirements that the invention is new and has other characteristics.
Exactly. You have to read the two together. Exactly as drafted in the UK Act, which is a patent may be granted only for an invention in respect of which the following conditions are all satisfied, and then it lists all four of them, including the exclusions.
But one of the criticisms of the Aerotel approach is it's not simply applying the exclusions to the invention that you start out with before seeing whether it satisfies the other conditions. It's building in some elements of novelty, for example, into the process, and there's nothing in the Act which justifies that.
But as a whole, what one's ultimately looking for is all of these conditions to be satisfied in the Act so as to define the patentable invention. You've got to go through all four. None are given priority. None are given you must do industrial applicability alongside inventive step, or you can only do industrial applicability after inventive step. The fact is you've got four things to do, and you're entitled to do them in whatever way you choose. And in the Aerotel approach, whilst we allow obvious removal of stuff which is not going to get through novelty or inventive step in order to focus the attention on the real issue, with the safeguard of the actual contribution, we've got to do one thing first. And the consequence of convict...
Well, you have, but isn't the logical structure of the Act that what you decide whether is new is the invention, and that is whatever is claimed, excluding anything which is deemed not to be an invention by 1.2. And then it's that you decide whether it is new. It doesn't, as it were, contemplate building in a bit of what is question of what is new into deciding whether something's an invention in the first place.
Well,
and once you do that, then the question is how much?
You could start
what's
saying,
the benchmark?
You could start saying, well, okay, let's define invention first. But invention has got, as a generality, but invention isn't tied to excluded subject matter. It isn't tied to inventive step. It isn't tied to industrial application, and it isn't tied to the invention being new. It's a much broader class than any of those. So yes, your lordship is right that at a level there's this thing called an invention. But how do we work out what an invention is? We do it by it needing to be new, needing to have inventive step, needing to have industrial application, and not being on the excluded list.
They're patentable.
Which then leads to the patentable invention. But there's trying to define invention without taking account of any of A, B, C, or D. It really is totally at large. And it certainly isn't tied to subsection D and subsection D alone. Why isn't it tied? If one wants to tie it, why don't we tie it to whether it's new or not? The fact is all four count equally, and it's wrong to suddenly say invention in the first line must somehow be dictated by sub D. Practical differences. What really matters is whether we can find actual instances of divergence. And given the EPC has been enforced for approaching 50 years, and even Aerotel and any hardware plus convic have been settled law for a very long time, it's surprising we don't have any. Aerotel, Court of Appeal, 2006. Convic in the EPO, 2002, and has been consistently used for decades. It wasn't until 2021 it was approved by the enlarged board in pedestrian simulation, but convic itself comes from 2002, 20 years ago. And even since pedestrian simulation, which was 2021, 4 years ago, there has been plenty of opportunity to establish practical examples of real differences. And this is especially so as it's quite common for parallel applications to proceed in the UKIPO and the EPO. Yet not a single example of the EPO allowing a patent application, whilst the UK rejected it for excluded subject matter, have been provided by the appellant or even the interveners. And of course, we need to bear in mind that the cases aren't just neural network cases, they're not even just computer program cases. The two tests are used for all of the exclusions: business method, computer programs, aesthetic creations, and so on. And we note that the interveners express the view that their members have experienced divergence, but not even the nature of the alleged divergence has been explained.
One has to be a little bit careful here, because it may be that some of this is down to the inclinations or particular decision in any particular case varying from one tribunal to another, in applying precisely the same principles in the sense that they have to deal with each of these objections, but some offices may lean towards granting and leaving it to the relevant other businesses in the field to bring oppositions to the grant of the patent. Others may be much more, other offices may be much more restrictive about the approach they take, but that doesn't necessarily mean that there is some difference in fundamental approach.
Well, certainly, even if there were examples we could be looked at, we would be in exactly that territory and saying that this feeling of interveners, that one jurisdiction is slightly more favourable than another, could be looked at. When we're faced with an appeal where this court is being asked to say that the Aerotel test is substantively different to the EPO as a matter of substantive law, you would expect in the last 20 years of both tests being run in parallel and patents from nigh identical patents proceeding in both the EPO for European grant and in the local office for UK grant, as indeed my learned friend's application is progressing, one would expect to have at least one example across the whole of the Chartered Institute of Patent Agents, the whole of the IP Federation, everything my clients know as the Intellectual Property Office. Where are the examples? Where are just a pair of patents going through, one being allowed by the EPO, one being rejected by the UK, or for that matter, vice versa? The fact that there aren't any should be of real concern to this court against the propositions that my learned friend is trying to make theoretically that there might be.
Nevertheless, would there not be an advantage in having the approaches brought into alignment?
My Lord, what we see, a couple of reasons, there's good reasons why they don't come into alignment. We have to remember that the EPO is not a Supreme Court. It is just the granting body for Europe. There are all the other contracting states. We don't have the equivalent of the CJEU that in times gone past this court had to respect. We clearly look at what the EPO is doing, and we try to ensure that substantively we don't differ. But when it comes to procedural applications, my learned friend's own research is that all of the EPC contracting states are basically doing their own thing. They don't follow the EPO. When the question of whether this court should adopt problem solution rather than Pozzoli came before this court in 2019, this court said no. Because the EPC...
Well, it will probably show us that soon, but there's a line of authorities, including Aerotel itself, I think, and certainly Symbian is very powerful, saying that if there's a settled approach of the EPO, particularly the enlarged board, we should follow it, unless it's clearly wrong. And the reason they didn't in Symbian was because they weren't satisfied at that stage that it was settled. But now I think you would accept that it is, and the approach of the EPO. And so you're inviting us to take a different fundamental approach from the one that the Court of Appeal in Symbian, for example, and it's found in other cases that I've looked at,
including
Aerotel itself, is the basic attitude that we should adopt in this jurisdiction towards the jurisprudence of the EPO.
But I draw a distinction between the substantive law and the procedural law.
But this isn't procedure. Procedure is about who looks at the application when and what and so forth. This is substance.
Sorry, so it depends.
I suppose
The way I'm using procedure, and I understand what my Lord Legate is saying, the way I am using procedure is how we go about the test. Do we end up applying the same article of the EPC in a way that generates the same results case on case? And the procedure I'm referring to is how we go about it. So one of the big issues with the EPO approach is that it does require you to use problem solution. And we've never used problem solution in the United Kingdom. We don't search for the closest piece of prior art, and we do not then seek to form with hindsight, a problem which can then be assessed for the purpose of inventive step.
But again, is that procedural? It seems to me the fact we don't do it, and the fact that the enlarged board has now said that convict rules okay, and that convict appears, although you haven't taken us through it in fine detail, to require you to do it, suggests that it's not just a question of procedure. It's not the order in which you ask questions, it's whether you use a problem-solution approach at all.
Well, that suddenly starts moving down the line of ceding our jurisdiction to the EPO and following whatever the enlarged board says. Now, the EPC is not harmonising statute in that regard. We cannot appeal from this court to the EPO. It's a parallel jurisdiction that sits as the granting authority, but it has other major differences. The EPO does not consider infringement. And one of the key things about Pozzoli is that the construction we use at stage 2 is used for infringement in this jurisdiction. Now, if you do problem solution and decimate the claim to move things from the inventive contribution into the excluded subject matter, you don't end up with a claim which you can use for the purposes of infringement in the UK. So how then do we do that?
I mean, none of these points was considered to be material in Aerotel or Symbian. No. They took it to be an available choice to follow the EPO, but they didn't, because at that stage there was previous English authority which they thought they ought to follow, unless there was a clear position from the EPO, which there wasn't. But if there had been a clear position, the implication of those decisions is then they would have followed it, and they didn't see a problem with that. But you're now saying the roof will fall in if we were to go down that approach.
My Lord, I think I would not take Aerotel quite that far. I think what one would say from Aerotel is, faced with the argument that you should ditch what the UK is doing and just adopt what the EPO is doing, the Court of Appeal taps out, for want of a better expression, at the point of, well, look, we're not even sure what the EPO is doing. It hasn't got to the enlarged Board of Appeal. Not, well, I see what they're doing, but we're not going to adopt it until it's endorsed by the enlarged board, and then we will adopt it on full.
Well, it's a rather odd distinction if you ask that question before the enlarged board.
Well, quite. We don't even know what the enlarged board is going to do before we know whether
well, that was the position in Aerotel. They just didn't know which way a live debate was going to end up. Quite. But we do now know where it's ended up.
We do.
And I can't help feeling that if one looks back at Lord Justice Jacobs' judgment in Aerotel, he would say, well, if only we knew, we would follow.
One says that once you know what you're faced with, what you know what the enlarged Board of Appeal are, then you move to the question of are there good reasons to adopt it? And starting point for a good reason to adopt it is because it produces a different result. What I mean by substantive change in the law. If it's insubstantive, then one has to look at, well, why do we prefer Pozzoli? What are the problems with problem-solution approach?
If you go to any hardware approach, you've got to change to config.
You do.
Or you have to change to Pozzoli plus 2A.
Yeah.
And I was just interested in what the prospective or retrospective effect of a decision in this court would be on applications that are in the process of being considered and on applications that have already been made, so that somebody could potentially appeal out of time and say, well, look, you should have applied the hardware approach. That was always the law, and it was we're just declaring what the law has always been. And if you had applied the hardware approach plus config or plus Pozzoli, then you would get a different result. I need my patent, please.
Your Lordship is absolutely right. That
well, your case, it wouldn't produce a different result, but it's exactly the same result, so we didn't worry.
Therein lies the problem, Lord Legger, that we say it doesn't produce a different test, but we have no control over the applicants who have not been granted a patent, who then say, well, everything's up for grabs now, particularly where Pozzoli, the proposal from a learned friend, paragraph 2A, really boils down to include that which you should include, exclude that which you should exclude, but keep the entire claim in mind. Basically, do Pozzoli, but try and keep a bit of config about it. Now, with guidance like that, it is a free-for-all, the people coming back, people asking for re-examination on matters that are still open within the office. It feeds into what happens on infringement. It feeds into the way in which we do inventive step in all other patent cases, because it's a nonsense for the court to have problem solution if the exclusions arise, but Pozzoli if the exclusions don't arise. Everyone will be saying you're using the wrong test. There's got to be one test that runs all the way.
The irony in this case is that the appellant says it would make a difference if we move to the any hardware plus config, and you say it doesn't. And on the appellant's case, then you've got problems about prospective, retrospective, and on your case, you don't.
Exactly, and it's not that clear where my learned friend really ends up, because he says, his questions 3 and 4, that the Court of Appeal got Aerotel wrong anyway, and he should have been allowed his patent. He says he should have been allowed his patent on any hardware or any hardware plus convict, but it's so far been refused in the EPO. I mean, you've got the general problem that my learned friend says he wins any which way. When you try to join them up, it's actually difficult to see why. The way his written case was written was very much on the basis that I only need to get this court to adopt the any hardware bit. Don't worry about convict, don't worry about Pozzoli, that's for another day. And it's only realised in the course of all, or in the preparation for all submissions, that that doesn't work, and he needs to hand up the modification to Pozzoli. And
Well, as someone who's not familiar with Pozzoli, at some point I'll need you to explain why it's going to mess up the Pozzoli test, which you say is so important, if we were to accept the submissions of the appellant. I mean, you'll need to make that good and refer to Actavis if you think that's an important authority in your favour.
Yes.
Well, I note in Symbian, the court did observe that if this court was seen to depart too readily from its previous carefully considered approach, it would risk throwing the law into disarray.
Quite, my lord.
That's in the context of errata.
Yeah. One has to be very, very careful with these multifaceted elements. We've got, as you can see, the four categories of considerations as to patentability that come in Section 1 of the Act are the exclusions, novelty, inventive step, and industrial applicability, with the exception of industrial applicability, which rarely seems to cause any issue. Whether something has inventive step or the exclusions are potentially there across the board. And we have no representations here where people are seeking to deal with the question that was before this court in 2019, which is whether we should discard Pozzoli for the purposes of inventive step. Yet we're now leading into that if we have separate tests for those patents that might trigger excluded subject matter and those patent applications which do not.
May there also be a distinction between a case which is before the office and the dispute is, well, now what approach should be followed? Let's say for a new case going forward, and a case which has reached this level on appeal. Now, it's true that in the interim there has been this decision of the enlarged board, but is the reasoning and conclusion of that board such that one can say that the approach adopted in this case is wrong? How could the outcome in this case be different if the other approach were to be applied?
Well, quite. That's what is missing from my learned friend's application, because he was proceeding on the basis that if he satisfies you as to any hardware, he didn't need to show you that he would
well, I asked him to, he didn't.
Sorry, say again?
I asked him to, and he didn't.
Yeah. He doesn't want to show you how he would fare under any hardware plus convict. And it comes down to, it's similar to the reasoning in Act Harvest and ICOS, that this court said ultimately the statutory test is what matters. We're not going to force on the courts any hardware, not going to force on the courts problem solution. The courts routinely follow Pozzoli. They're entitled to continue to do so, but it would be overstepping the mark to force either of the tests.
Well, are you going to give us the reference or show us the passage? Or?
Find me that in Act Harvest, yeah.
I think it would be very helpful before the short adjournment if we went back to the Supreme Court decision which approved Pozzoli.
Yep, that's right.
Yes.
Yeah. Is it not the right one?
No, but it's not. It's right.
My Lord, if it helps, just give me time.
Yeah.
I think the relevant passage is cited in my learned friend's written case under 82. It's on page 107 of the bundle. Yeah. And you'll obviously see what's important in that is it suggests that no one has ever suggested the problem-solution approach is the only way to go about considering obviousness. Likewise, Pozzoli provides a structured approach which may assist in avoiding and may be helpful in some cases more than others. No formula should distract the court from the statutory question. So the point that's made in this passage is that they are approving it as an application, but they are not approving it as the only application. And that's the point I was making yesterday, my Lord.
And that's the same point I was saying, when it comes to what my learned friend is asking for, is a prohibition on the use of Aerotel. The reality is that Aerotel is there and is the test. Convict in the EPO is there and is the test that they use. It would be just as wrong to force any hardware plus convict on the UK courts as it was for not forcing
problem solution on the courts in Actavis and ICOS. The only reason to say stop using Aerotel is if my learned friend can convince the court that Aerotel doesn't produce the right result. It's a tool. And a tool that produces the same results and works in our system, and has worked in our system for the best part of 20 years, shouldn't be thrown out for a tool which was designed to work in another system.
Is the relevant passage of Actavis the one quoted there, or is there more than that?
It is. It probably needs to be looked at in context, but that is the key passage that we've included. And when I went for the authority in the bundle, the appellants have filtered the tab down, so we haven't got the full case there. But we'll make sure it's provided to you.
It's page 331.
Yeah.
I see there's some pages missing from it.
Yes.
Yeah, that'll be helpful.
Yeah.
But there'll be a lot of jurisprudence on the approach to be adopted to obviousness. How to assess the common general knowledge, what's the skilled man going to have in mind, what, if anything, would be obvious in the light of that.
Exactly, decades and decades of learning. And the same on problem solution in the EPO. It's how they do inventive step. Decades of learning. And
taking the closest prior art is a very practical solution if one's I don't mean this disrespectfully, a patent office, because they don't have access to the average skilled worker in the field.
They don't have experts
and the
as
general
we have in
knowledge.
the court system. Yes.
Or the benefit of necessarily of these reports that we have here, Professor Pardo and the like. That's a much broader question.
It is, my lord, and that's where the concern comes, as this appeal has morphed into modifying Pozzoli or actually adopting convict. So I think my learned friend was really advancing this on, you don't need to adopt convict, he says so in terms, and you don't need to modify Pozzoli. And moving to convict is really moving to problem solution and away from Pozzoli. And as my Lord Kitchen has referred, it's at the heart of our patent law and involves a completely different procedural aspect, such as the way in which we have evidence brought, the way in which we allow limited numbers of pieces of prior art rather than great swathes of prior art that then come down to one by the closest prior art solution. How you determine the closest prior art, how you assemble the problem solution itself in such a way as you do it with hindsight, but seeking not to leave hindsight-led signposts towards the solving of the invention. A huge amount of case law and difference in approach. And I've also pointed out that we've always had as a fundamental concept in UK patent law that you construe the claim once and you use that same construction in the courts for validity and for infringement. Lord Justice Jacob, I think, used to refer to it otherwise as the Angora cat, where the cat is all fluffy, and for the purpose of infringement, it fluffs up its fur and goes as broad as it possibly can to try and catch the infringement cases. But when it comes to validity, the hair goes down and the same cat tries to be incredibly thin so as to avoid the prior art. And what we've always said in the UK courts is you construe the claim once and use it for both parts. And the construction under step 2 of Pozzoli is done for the purpose of validity, but it's also used for novelty and it's also used for infringement. It's the same test. The EPO doesn't need to worry about that because it has no jurisdiction whatsoever to deal with infringement. It is purely a granting authority. And as my Lord Kitchen mentions, it has very little assistance in terms of experts, and it's very often ex parte, only one side present. Whereas in the courts we have both, we have extra learning, and having formed that construction, we have to use it consistently. If we suddenly start using problem solution for validity, we then need a problem solution equivalent for infringement. But problem solution isn't about finding the scope of the claim in the way you need it for infringement. Certainly not modified problem solution where you start deleting features, because for infringement, all of the features of the claim must remain present. So there's a fundamental incompatibility with the tests. And my learned friend suggesting effectively on his feet, as he did yesterday, that you can just flip over to convic or flip over to a modified form of Pozzoli is a wholly different appeal to that which he is really brought. My lords, I do see the time.
Yes. How are you doing? I've got a feeling you're falling back a bit behind your...
I am falling a little bit behind. Yes, I'm a little bit behind, but I'll discuss with my learned friend, Dr. Edward Stewart.
You get an extra 10, a pair of you get an extra 10 minutes at the end beyond the original time.
You do.
Yeah.
And somehow or another, my lords will make it work.
Okay.
Great.
2 o'clock.